considered essential. There are broad categories and then subcategories within them, and then there are a number of open items. The key point of that guidance is that the essential business rule is being determined on a state-by-state basis, and one has to go to the governor's stay-at-home order or essential business order to determine if you are an essential business. Unfortunately, that doesn't cover all the businesses, and so on each of these orders, there is a website or a telephone number that you can call to either inquire if you're an essential business or to advocate for you being an essential business. One tactic that we have recommended is that if you are part of a state trade association for your business, a construction group or an appliance store group or a pawn shop group or a medical group, contact them first. They may have been in touch with the governor's office and already received guidance. If in fact you are an essential business, it's important for you to generate a letter for each one of your employees when they're traveling about to say that, one, the governor has issued an order, declared your type of business to be essential, and that the employee carrying this letter is either traveling to and from work or engaged in the business at hand and therefore is essential. The next area, and that's covering sort of who's essential, and we're suggesting you take a somewhat broad view about what's included. If you work down far enough, you won't be on a list. If you take a little bit broader view, you might be. The second question that people are facing, even if you're essential, the question is what if you're hampered or you can't perform your contract obligations? And that might happen if there's a base closure for safety reasons and things like that. One of the first clauses that everybody turns to is the excusable delay clause. Federal contracts don't have force majeure clauses like your subcontracts and private sector contracts. So you need to go look at that. And the question is, it's not a total excuse necessarily. It's whether you're delayed and what are you required to do. A key point is if it's a fixed price contract, you need to give notice within 10 days that you run into a problem. You need to keep records of the costs you're incurring in trying to resolve it. And the most important thing is you don't want to tell the government that you can't perform. What you need to be is in contact with your contracting officer and be flexible. Have a discussion about ways that you could perform. Is it possible to do something remotely? Can you share your workforce or stagger your workforce so that half are on or half are off? Can you alter the scope of your contract so that at least some of your workers can continue to perform? As I've said, keeping records is going to be critical. There are going to be many, many claims when the government reopens and society returns to normal, so you need to be monitoring that. If there's a termination for convenience, you need to be aware of that and again keep records. There are a number of things that that others are going to talk about, the CARE Act, if you have to lay off people, and you need to be thinking about your employees. The one thing I'd note from a government contracts perspective is that if an employee advises you that they have become sick in connection with work, OSHA requires you to keep an ongoing log of information like that. Stephanie and Merrill, I think, are going to talk about the Family First Act. Others are going to talk about the CARES Act. But it's important to stay in touch with your employees. Keep them in the loop about what you're doing and what the government's saying. And lastly, I wanted to touch on, are there business opportunities to serve the nation? And the answer is yes. There's been a declared emergency so that the simplified acquisition regulations are applicable to commercial items up to $13 million. Key areas that you should be looking at is the Vice President's Task Force, BARDA, which is part of Homeland Health and Human Services, which if you have drugs and related items is a good source. And then FEMA is supposed to be engaged in some of the logistics although I will say that that agency is encountering a number of challenges. It's not exactly a time to break into the government contracting world, but use trusted contacts, use the contacts you have, and be persistent. Contracting and program personnel are overwhelmed at the moment, but if you have a good idea and you want to pitch it, if you keep at it, someone will answer the phone. And with that, I'll turn it back to you, Mark and Clint, and answer questions later.
Thank you, Tony. So at this point, we will turn it over to Stephanie Barone. She is a principal at Miles and Stockbridge. Thank you, Stephanie.
Thanks, Mark, and good afternoon. My name is Stephanie Barron, and I am, as Mark said, a principal at Miles and Stockbridge in the Labor and Employment Group. So traditionally, I'm representing management in all areas of their employment needs, from hire to fire, with employees and everything in between. Do a lot of counseling and also litigation if it gets to that. But as with many of you, I've been focused almost exclusively over the last month on COVID issues, including the Families First Coronavirus Act and the requirements that are in that law for providing paid leave to employees, including for small businesses. While many of you may be aware, there is an exception for businesses of 50 or fewer employees. It's very limited, not automatic, and requires you to make certain attestations and keep certain documents, and to do it on an individualized basis for each employee who requests leave, when you make a consideration about that, and whether or not you can in fact provide the leave. So backing it up a little bit, the FFCRA does provide for two forms of leave: earned paid sick leave and extra or emergency family medical leave. And again, it will apply for all employees, just about, for employers of 500 or fewer. And as I mentioned, there are just some very limited exceptions. So I'm happy to answer questions about the FFCRA. Also do a lot of work with employee issues related to, there are a ton of issues right now related to furloughs and layoffs and even salary reductions. And there are a number of issues that you have to consider if you're considering those possibilities for your workforce. Not to mention the crossover with the Paycheck Protection Act, which I believe Tim is going to be talking about, and how it relates to those things. But there are the regular old state and federal laws that apply that you have to consider and make sure you're giving enough advance notice. If you're providing a salary reduction, that you're making sure you're still paying in compliance with federal law, the Fair Labor Standards Act. None of those laws are suspended or overwritten by the other statutes that we're talking about today. So happy to answer any questions you have around the FFCRA or traditional employment matters as it relates to how you're paying your employees or dealing with them or considering layoffs and things like that.
Thank you, Stephanie. At this time, we'll turn it over to Tim Johnson. He's the director at George Mason SBDC. Tim?
Thank you. Good afternoon, everybody. So I'm Tim Johnson, and I run the center, Mason SBDC. It's a center in Fairfax that covers all of Northern Virginia, primarily with Fairfax, Arlington, and Prince William counties, to provide counseling resources for small business owners and entrepreneurs. And we are directly funded by the SBA, so we are, you would say, at the tip of the spear in providing information about what's happening. I'm going to go ahead and hopefully quickly do a slideshow here for all of you, and specifically wanted to talk about the CARES Act and what assistance is out there for small businesses. It really comes in a couple of forms. And the SBA, our website at the Mason SBDC, as well as the Virginia SBDC website, keep all the information current and hopefully easily navigable, so you'll be able to get the resources. However, if you do need to seek counseling, all you have to do is reach out to one of our centers, and we're happy to help you. So the primary loan that was made available now, it's been 2 weeks for for Virginia companies is the Economic Injury Disaster Loan, also known as EIDL or EDL, if depending on you want to talk about it. And this is specifically for businesses that have had injury, that have employees up to 500. It does include nonprofits, associations, and independent contractors. And primarily, it's a loan provided directly from the SBA. The idea is that when you apply through the portal, and once you're approved, you'll be able to get funding that that will be potentially up to $2 million. The idea is it's going to be based on roughly 6 months of your operating expenses is what you'll be eligible for. And the term of the loan can be up to 30 years, and it will be at a fixed 3.75%. Some of the nuances about it, though, is there potentially collateral and guarantees going along with it. You as the business owners would still be responsible for paying this loan back, though it may take 30 years. However, there's some provisions. If you are only borrowing a small amount up to $25,000, there is no collateral or personal guarantee. If it's under $200,000, you waive the personal guarantee, but you still may have to pledge collateral. And the payments won't begin to be required to begin to be paid back until 12 months from the point of the loan closing. The loan proceeds can be used for what we consider working capital. That's things like payroll, rent, and certainly keeping the lights on within your small business. And then once the CARE Act was passed, they added a second provision to the EIL loan, and this was a grant of up to $10,000. And the idea was they were hoping to make it available for small businesses 3 days after submitting their EIDL application. So you submit for the full application, there's a checkbox near the bottom, and that you're requesting the $10,000. We've had numerous of our clients actually have submitted on Monday, and we've yet to hear anybody that's actually received their $10,000 by today. So I think they're a little backed up, but we're waiting anxiously to see what happens. Should your should your loan not be approved, you will not have to repay back the $10,000 grant that's been provided. There are a couple of other provisions that are also out there. Should you be working already with an SBA lender, that's a commercial bank that does SBA loans, you can actually get a $25,000 bridge loan if you work directly with your bank, and then that can be, you would say, paid off once your EIDL loan is approved. And then for those who actually have 7A loans or 504 loans already on the books, the SBA will actually cover your principal and interest payments for 6 months. So it's certainly a way of keeping current with your existing loans if you have them. A couple of other tips and questions that were often asked. First of all, if you do have other loans, it will not affect your eligibility. They are going to look at your sort of overall credit worthiness and really understand what you ultimately need as a decision for what they're going to allow you to borrow. But having already existing loans on the books won't disqualify you. The second is the portal itself, which has been significantly improved since when it first opened. Still has its challenges. It was recommended that you use Internet Explorer or Firefox as opposed to Chrome when you're putting in your application. Recommend that you download the PDFs of all the forms you'll be submitting in advance, prepare them, and then when you're in the portal, every time you upload, save and save frequently, and that if the system does crash, you'll be able to pick up where you left off. The next particular loan area that the grant provided, or the CARES Act provided, is something called the Paycheck Protection Program, or what we're referring to as the PPP. And the idea is it's a loan that you're not working with directly through the SBA, but you're working with an SBA approved bank. And this particular loan has no collateral or personal guarantees with it, but the idea, it is primarily to focus on payroll. Your eligibility amount will be based on your historical payroll. They look at your 12 months of payroll divided by 12 to get your average, and then multiply that by 225% in order to come up with a loan amount. And the idea is that that once your loan is approved, the expectation is you will bring your employees back, or if you've not laid your employees off, you begin to pay them using the proceeds from this loan. Anything above the payroll you can also use for things like rent, utilities, and some other operating expenses. And while it is a loan to start with, the good part is that part of the loan will be forgiven up to 8 weeks of your payroll, assuming you've made payroll, and you will actually be required to prove that you've made payroll, and that begins from the point that your loan closes. So, the part that's not forgiven and that you may be using for other things will be based on a 2-year term, and the interest rates will be at 1%, and the loan payments won't begin until 6 months after you receive the loan. A couple of things that you'll need to think about when you do this. You'll need payroll documents, 3 years of both personal and business tax returns, and financial statements to support this. You will be working with a local lender, and once you have received your loan and you're ready for forgiveness, you'll need to talk to the bank, and they should be giving you a decision within 60 days about the forgiveness portion of the loan. There'll be lots of verification on the forgiveness part that you'll need to be able to keep track of. And then lastly, there are a couple of other provisions also to help small business. Will be a portion of your payroll tax, that's your Social Security and Medicare portion, for your federal contribution, that you'll be able to get a tax credit for 50% of the wages that are paid. And then also for future payroll taxes on the employer side, you'll actually be able to defer them until 2021 and allow you to hold off on those payments. Could be a bit of a challenge if you're working with a third-party payroll company. We've yet to understand if they're ready to support the employer payroll tax deferment. And then lastly, we say, well, how fast does all this take? What the SBA has said is expectation is review and approval on the EIDL loans within 21 days. We're hoping that's true, but typically these grants were for local disasters, not nationwide disasters. So we're a little concerned that this may take quite a while for them to get through their backlog. And as of today, the PPP loans were to be made available, though I'm not sure the banks are going to be fully ready today, and it will be at your bank that you're working with speed in order to get to see how long this takes to get the loans through the process and funding into your bank account. So with that, I'll go ahead and bring this back to the team. So back to you, Mark.
Thank you, Tim. Appreciate it. Next, we have Meryl Renaud. She's with counsel with Miles and Stockbridge. Thank you very much. Meryl.
Thanks, Mark. As Mark said, I'm an employment attorney with Miles and Stockbridge in our Tyson's Corner office. I handle all aspects of employment law, and particularly with respect to government contractors. Today, I'm going to be talking about unemployment, the changes in the Virginia rules and federal rules relating to COVID-19. And to put this issue in context, over 2 million Americans filed for unemployment in the past 2 weeks alone. That's astounding. In Virginia, for the week ending March 21, the number of initial claims filed with the Virginia Employment Commission increased from 2,706 the prior week, and now it is 43,571 in 1 week alone. So it's a very important issue for all employers and in particular to all employees. The general eligibility requirements have changed a bit. Usually, in order to qualify for unemployment, you have to be able to work and terminated through no fault of your own or furloughed and not getting paid. If you experience a reduction in hours and pay, you can collect as long as what you're receiving doesn't exceed the maximum you can recover under unemployment. But eligibility has been increased and extended because of COVID-19. And on the Virginia front, there are two things that Governor Northam has done. First of all, beginning with the claims effective March 15th, the governor has directed that there's no longer a waiting period. You can apply the day after or the day you're terminated and be eligible. And there's no requirement right now to conduct a weekly job search because that's not going to be very feasible at this point in time. In Virginia, the infrastructure for filing claims is overwhelmed. They are accepting claims, but there's a glitch in the system and nobody's getting confirmation that their claims have been received. So that's a little troubling. They're working on it. And how fast people will be able to get money for unemployment depends upon how fast they can process the claims. They're saying 1 to 2 weeks. That sounds pretty aggressive. There are significant changes on the federal level that are being implemented through the local state unemployment commissions. First of all, workers who used to not be eligible for state unemployment, like gig workers, 1099s, independent contractors, they may be eligible now. And Governor Northam has encouraged all of those independent contractors who aren't able to work or receive money at this point in time to file claims. Also, Virginia's unemployment insurance program before COVID paid out between $60 and $378 maximum a week for between 12 and 26 weeks. Due to the CARES Act, their additional unemployment benefit payments have been increased $600 per week for up to 4 months. The current expiration date is July 31, 2020. And this extra $600 a week applies to full-time as well as part-time employees. And someone who files a claim for unemployment is eligible for this increased amount, even if they'll get paid more than what they were receiving when they worked. So I'm curious to see if it is a disincentive to work. You're going to make more filing for unemployment. So right now in Virginia, you can receive up to $978 a week in unemployment, the $378 max plus the $600 a week. And the CARES Act also extends the period of time by which you can file for unemployment. So there's an additional 13 weeks of continued $600 weekly payments for individuals who remain unemployed after they've exhausted their state unemployment benefits. So as a general rule, employees are now eligible for up to 39 weeks of unemployment. The Virginia Employment Commission is not currently giving the extra $600. They have to work out an agreement with the Department of Labor. It should be in effect soon, but claimants will automatically receive retroactive enhanced payments once that agreement is in place. And finally, the CARES Act expands unemployment eligibility to individuals who were able and available to work, but are unemployed, partially unemployed, or unable or unavailable to work due to COVID-related reasons from January 27th until the end of the year. And in order to receive unemployment for a COVID-related reason, they have to certify that they are sick, that they have been diagnosed with COVID, a member of their family's been diagnosed with COVID, or they're providing care to a family member with COVID, or they have a child or someone in your household, and they're the primary caregiver and school or the care facility is closed due to COVID. The individual is unable to go to work because they've been advised by a healthcare professional to self-quarantine due to COVID. They were scheduled to start work, but they can't work because wherever they were going to work is closed due to COVID. And the individual has quit their work as a direct result of COVID-19. I don't know exactly what that means, but we will find out. And Governor Northam has indicated that he wants unemployment to be available to anyone feasible and to be very exhaustive in the interpretation of eligibility. But with the rise in claims and the depletion of the fund, we will see how that plays out. Who is not eligible for unemployment due to COVID? Generally, an individual who stops work out of a general fear of COVID will not be able to collect. It's going to depend upon the reasonableness of the fear. Was there somebody at work who had COVID? What is the employer doing to protect the employees against COVID? And other individuals who are not eligible would be those who can telework with pay, who are receiving paid leave under the employer's plan or state and local plan, and new entrants to the workforce who just can't find employment. Virginia says that businesses that pay for unemployment insurance will not be penalized for this spike of unemployment-related claims. However, the governor has also indicated that there is going to be a general increase in the amount the employers have to pay in order to ensure that there's enough money to pay out all the claims. So the bottom line is, in order to encourage your employees, if you can't pay them, tell them about their unemployment opportunities. You don't decide whether or not they collect unemployment or if they're eligible, but encourage them to apply and that you will support them to the extent reasonable. And with that, I will turn it back to Mark.
Thank you, Meryl. Appreciate it. Our last speaker is Edward White. He is an attorney with Williams Mullen. Edward.
Thank you, Mark. Can you hear me okay? Excellent. Well, thank you, everybody, for having me on the call today. As Mark said, I'm a partner with Williams Mullen, and I'm a member of the intellectual property team at the firm. I'm going to speak briefly today on just a couple of intellectual property issues that I think people want to try to maintain in the background as they face these unprecedented conditions. Obviously, I realize that there are a number of things that are going to be critical, like the PPP, SBA, and other stimulus packages that small businesses need to get their arms around immediately. But also important are your intellectual property assets, because they really are critical to any business. So as you move forward and as we adjust to these new working arrangements, et cetera, I want to point out four things, at least four things, that you should be thinking about in the short term with regard to your intellectual property portfolios. The first thing I'd like to touch on is your portfolio management. Many of the people, many of the entities on this call certainly have assets such as trademarks, copyrights, patents, trade secrets, et cetera, things that are proprietary to their business, things that really create value for their businesses that they provide to customers. And many of the entities on the call will have invested in the application or registration process for many of these assets at the United States Patent and Trademark Office, the U.S. Copyright Office, et cetera. It's important to ensure that you are keeping track of the upcoming deadlines that you have for many of those applications and registrations that are in the pipeline. There are policies that have been promulgated because of these extraordinary circumstances to help alleviate some of the immediate pressure to maintain deadlines and meet deadlines. But eventually the deadlines will need to be met to maintain these enforcement tools. And so I point that out as just something to keep on your back burner, possibly towards your front burner, to ensure that you're not missing those deadlines going forward. The second point I want to make from an IP and really almost cyber perspective is that as we use platforms like we're using today, Zoom and other video calling platforms to work with our clients, we really do need to make sure that we are ensuring IT and cyber security when we're using those. There are a number of ways through video calling services that you may inexplicably be providing data and or information that you may not believe you're providing to the participants on the call. And there are ways and processes that we can put in place to help you maintain security so that you don't end up doing that. The third point I'll point out is that as we work remotely with clients, it's likewise important to ensure that we have proper IT safeguard in place. I will just point out a quick example of a client that I currently have who has decided that they are actually going to be using robotics in their own client facilities. This has brought to bear the need for new agreements or amendments to their master services agreement to make sure that the robotics that they're placing in these physical locations are properly memorialized, how they'll be maintained, how they'll be utilized, how they can be used by their clients, et cetera. So as we work remotely with clients, keep in mind that you may have to do some housekeeping to ensure that your existing service agreements are properly adjusted accordingly. And then the fourth note I'll make is just that as you move forward and you are looking at your service agreements, you should certainly make sure that you are, and I think most people on this call have probably already done this, but nevertheless, it should be an ongoing process. Ensure that you are looking at your supply chains, that you are identifying interruptions, and that you're mitigating those interruptions. In many cases, the best opportunity to mitigate some of these operations, both your own interrupted service and the services that are provided to you, will be through the force majeure clauses that are in your existing contracts. In many cases, those force majeure clauses are very general. I think going forward, we'll definitely see a movement in newer contracts, and these are things you should think about with your own service agreements in the future, to better define what creates impossibility with regard to providing services. In Virginia, the doctrine of impossibility, which is a common law doctrine, is really the one that comes into play in litigating majeure clauses, force majeure clauses. So certainly as you look at your supply chains and you look at interruptions, look to those service agreements to see if there are opportunities there to mitigate those things. So with that, I will turn it back over because I know we want to leave some time for questions and answers.
All right, thanks everyone. I think that was very helpful and gave us a good overview of what sorts of knowledge everyone has. If people have questions, I have a few that came in before the program started, but if people have questions for the panelists, if you could send me a text or use the Zoom chat feature rather to send them to me. I see a few popping up now. I'll start going through them and I'll try to feed them to the appropriate person with the correct expertise. But if I make a mistake, just speak up and tell me that that's not your forte, all right? So I think the first one that I received is probably for Tim. Tim, I think you addressed this in your presentation briefly, but this came in before we started. It says besides PPP, are there other what are the other primary loan programs I should look at? And I think you mentioned a couple of them, but if you could just repeat that real quick.
So the PPP is the loan program specifically to get some funding to focus on payroll, and that payroll, once you receive the fund, is primarily there to pay your employees that that we would want you to retain or bring back, regardless if you've had to reduce their hours or even lay them off during this period. The primary large loan for operating expenses is the EIDL. However, you're not restricted in any way to go after more traditional loans, which would be potentially the SBA backed 7A loan, or working directly with a local lender under your typical loan scenarios. Those interest rates are going to be higher. There is no forgiveness, and it may be that our banks are going to be fairly overwhelmed just servicing the deluge of applications they're going to get under these two programs. So we'll have to see how it shakes out. But really, those are your options. We have seen a few community-based loans or grants pop up. We would certainly suggest that you look at your local Economic Development Authority, Fairfax, Prince William, Arlington and see what's available. We're doing our best to track what's coming in. Some have had run out of time, meaning that the eligibility has gone by the wayside. So go ahead and take a look.
The next question is, it's my local bank has no information from the government yet on PPP. This was said yesterday. Do you have a sense of what the status is for the banks in terms of getting information on this and kind of putting steps in place to provide these kinds of loans?
Sure, and well, one of the things that was published is the sample application itself. And so you can get that at the SBA website. We also have it up on our websites, and it can get you ready to prepare to collect the information, ready to talk to your bank. I think where the banks are struggling with is what is the process, the SBA lender bank and the SBA themselves, and I think that's what they're working out. We've talked to a couple of banks, and they said the same thing as of yesterday. They weren't quite prepared, and I don't have any new updates to see when are they ready to, you would say, open up the loan process.
The next question, again, loans are very popular, as I would expect. The next one is, I've heard that this program is a first-come, first-served basis. Is that true? And if so, how does that impact the application timeline and the urgency?
Well, I would have to think that's probably what they're doing. We recommended from the very beginning, get your application in, and essentially you are in line. When you think about the SBA, I believe they voted something like 7,000 loan officers to begin to administer the applications. They're going to have to do it probably in order that they've received them. So the later you're in, the later you're likely to get your loan reviewed and then ultimately approved. With the commercial banks, my expectation is they will start working with their existing customers first, the ones that already have checking accounts and a banking relationship. So if you're thinking about, well, should I go to a different bank to try the PPP? Would say no. Recommend you go to your primary bank first. Most of our local banks are SBA lenders, and the SBA was quickly granting access to some of the banks that weren't. I know that is also going out. So start with your local bank. The SBA does have a tool up there where you put in your zip code, and it will give you all the local SBA lenders as a short list, as well as you can contact one of your local SBDCs, including my center.
The next question also is PPP related. We are an essential service, and they've had to cut their hours a lot, and they want to compensate them with funds for work slowdown that occurred prior to the time of the loan. So can they can they pay for that time either through a payroll bonus or back pay or something like that for time that the employees have already lost?
Right. So once your PPP loan has been approved and funded, that's when the clock starts, and your forgiveness of the portion that you're going to pay for payroll is going to be based on the amount of compensation you're going to pay to each of your employees, assuming it doesn't exhaust the loan amount. Requirements there's probably some limitation based on high earners. So the PPP loan amounts are limited to no more than 100,000 annual salary as part of the basis. So when you actually get to the point of now cutting payroll checks during sort of what I call the period of performance of payroll, I don't see any reason why you couldn't increase some of the pay to catch up some of the employees that were underpaid in the prior period.
Thank you. That's very helpful. So if the small business applications start on 4/3 and the independent contractors start next week on April 10th, if you are a multi-member LLC where the owners work in the business and take distributions to pay themselves, are they considered a small business or a sole proprietorship or contract?
So a multi-member LLC would be clearly a a partnership and consider just a traditional small business. When we think about independent contractors, solopreneurs, an individual that is working as a 1099 would kind of fall into that sole proprietor category. If you've not registered as an LLC and you are engaged in contracts using your regular Social Security number, that would be considered an independent consultant that would kind of fall into the sole proprietor realm. For inclusion of compensation as an owner taking a distribution, my understanding is that can also be included as part of the basis of what your loan amount would be, and you as a business owner can draw as part of compensation during that payroll period. They also allow independent contractors that if you have a 1099, let's say you have a 1099 independent bookkeeper, that can also be included in your overall payroll loan amount calculation. So a lot of nuances, and we certainly can help you to figure out what ultimately the maximum is. Another provision that I heard is that, well, traditionally you would say, well, what was my total payroll for last year, 12 months, and we'll take 1/12 of that as the starting basis. We also see that it can be seasonal. If you have a business that's seasonally driven, you can actually pick a different period to be the basis, especially if this current period when we're going to start making payroll is in line with a seasonal payroll performance. So some additional nuances coming out dealing with the payroll side.
The next question, Tim, this is from Thomas Chung. It says for PPP, it's up to 8 weeks. Is that up to, what does that mean in terms of what we're actually looking at?
So the idea is once you qualify for the loan and the loan is committed, you're getting forgiveness up to 8 weeks of payroll. So if you're making regular payrolls for those roughly 2 months, and assuming those payroll payments haven't exhausted the amount of the loan, all that will be forgiven. And so that's what that provision means.
Next question is, do we need to provide 3 years of tax returns for all employees or the owners of the business?
So the tax returns will be based on an individual basis, will be based on owners that own 20% or more of the LLC or the corporation. That's who would be putting it up. And then from the business tax returns, it would be if it's a partnership return or a corporation return, that would be provided. If you are just a single member LLC, it would be your personal tax return, primarily your Schedule C. That is a part of your personal tax return is what they'll be looking for.
Next question. Sorry, Tim, I think all of these are probably going to you, but some of these might get into the employment side of things, and I think they're really getting into tax questions, perhaps, which I don't think we brought a tax specialist today, but I may ask for people to volunteer if they think that this is more appropriate for them. This one is talking about 1099 employees that are used for federal government contracts. And they're asking, are there relief options that can be used for payroll expenses to pay 1099 consultants? And that may be, I don't know who wants to field that one.
Right. Well, so my understanding is they can be included as part of the basis, but there is a cap as to the total amount of that can be included, and I believe it's 100,000. So if you've got 1099 employees, that might not be nearly enough to allow you to have relief. But what the provisions are also looking to is those individuals themselves may have the opportunity to apply for relief themselves, if not even potentially through the unemployment rank. So I'll kind of turn it over to the HR, would say employee side to say if they're what their advice would be.
Stephanie or Meryl, do you have any further comments on that one?
I think that right now the independent contractors can file for unemployment, and what they're saying is the PPP is to compensate the person for the business loss. And the unemployment is to compensate the person for personal expenses, living expenses, their own personal rent. So it's not double dipping, and they should be able to get both at the same time.
Could someone talk a little bit about whether it makes sense to go with the PPP route or maybe just go with unemployment when that might be a better option, just suggest your employees get unemployment?
Well, so from my perspective, if the intent is to hopefully retain and maintain those relationships with those 1099 contractors, this is relief from the business's perspective that makes sense to support that contractor. And then hopefully when we're back to work, that contractor still hasn't, there wasn't an incentive to go somewhere else. I would probably have to say, from an individual contractor standpoint, what's better for them, and it'd certainly be the unemployment route, and they get more compensation and a better deal.
My business has been ordered to close because it's not an essential business. Should I apply now for PPP or wait until it's reopened? And will I get the money?
I would certainly apply now. Get in line. Assuming that you can collect all your documentation and be ready to submit it, I would go ahead and get it line because it will take the banks a period of time to get these things funded, and really that's when ultimately you can begin to actually pay your employees even though you're in a shutdown situation, and give some compensation relief to those valuable employees.
Okay, so even if I'm still closed, I might still get my money before I can reopen, is what you're saying?
Yes.
Does PPP, can you use that for part-time employees as well as full-time employees?
Absolutely. So there is no issue with that.
This is not specific to PPP, but can a company qualify, or a small business qualify for both 7A and 7B funds at the same time?
So the answer is the 7A program. Well, PPP is specific to payroll. 7A is typically a bigger, more traditional small business loan, either a term loan or part of a line of credit. The answer is that, yeah, they both can be done at the same time. PPP is going to be specific to that economic injury and getting relief for you for payroll, so they can coexist. What the traditional EIDL loan, however, which also can cover payroll, the SBA is saying you can't use proceeds from both loans in order to pay payroll. So they're saying no double dipping in that aspect. How they manage that and monitor that, I'm really not sure, given that funding is going to go into your general bank account, and how you spend the money may be interesting to document. Though the word is, the disaster loan and the PPP should not be used for the same expenses. Sorry, I'm not hearing you if you're addressing me. Sorry.
I think you have it on mute right now.
Sorry, I moved my mouse out of the window, so when I hit the space bar, it was no longer unmuting. My apologies. So another PPP question, can you apply for PPP and disaster loans concurrently, or are they PPP loans like a subset of disaster loans?
They can certainly be done concurrently, and we're actually encouraging that. Both are going to take a period of time to fund. One is funding from the SBA, the other from your commercial bank. Even if you receive both sets of funds, and as long as you don't use the money for the same purpose, we would hope that you certainly can take advantage of it. Build some working capital to be ready to open the business once we're ready to do that.
I'm asking the question, and I might be misunderstanding this, but if there's an 8-week period during which the loan needs to be used in order to be forgiven, but my business isn't open, how do I mesh those two things and use the money?
Certainly understand that situation, and it's very likely that we won't be open for business. The idea is that even though you're not open for business, the government would like you to pay your employees as well as yourself during those 8 weeks. So it's giving employment compensation even though no work is actually being performed. So there's nothing wrong, with that. So it's hopefully is certainly what the incentive is. The other usage of the PPP could be for making rent payments, interest payments, things that fall under the PPP category that may be in addition to payroll.
Okay. If I don't pay myself a salary, and so I don't have a pay stub, but I pay myself through distributions, how do can I show that as a payment for purposes of the PPP?
So for first calculating the loan amount, you would include your distributions, and of course you'll be showing evidence of the distributions with also the payroll related documents around the W-2s and payroll records for your employees. When it comes time to actually begin to distribute those funds through payroll, all you need to do is show document evidence that you were receiving some of those funds as if you were an employee, though not necessarily going through your payroll service.
I think I've gone through all the questions that we've received online, both prior to.
I have one more question, if I may. This person wrote in and said they work in the video production industry and they rely on freelance workforce for most of their employee costs. Are 1099 contractors. Will they be classified in the same way as W-2 employees with regards to obtaining financial relief? And if so, how do they make that claim?
So as they pull their documentation together, and you can clearly identify the independent contractors that you've used over the course of, say, 2019, which will typically be the basis for calculating your total payroll, and your independent contractors. There is a limitation as to that if you had several $100,000 worth of independent contractors, I believe it is capped at $100,000 in order to come up with your monthly average. So that is establishing your loan basis. Once you begin to disperse that funding, it is certainly up to the business owner to decide if they are going to include any of their independent contractors to receive compensation. If they don't, none of that will be forgiven, and they'll ultimately be paying that loan back over the course of 2 years.
So I think I have a follow-up to that. Is PPP only for businesses with 3 years experience?
My understanding is no, as long as you were in business as of February 15th of this year, I think is what we understood as the cutoff date. However, you don't have a lot of history of experience in payroll. It may be challenging if you've only been in business for a month, you may have a difficult time showing what you're eligible for.
Understood. All right. Have I missed any questions? Does anyone have one that either I did not address or that you've thought of now and would like to pose before we sign off?
Clint, this is Tony Anikeff. I wanted to put a little bit of a cautionary note out there. A lot of companies and persons are going to be seeking loans and other relief, and it will be their first time engaging with the federal government, either directly or through the states. And having been through some disasters before, when we get through all of this, auditors and investigators are going to be combing through this for abuse. And when people are in extremis, they sometimes pad the record a little bit. These are all submissions going to a state government or a federal government, and accuracy in your submissions is going to be paramount, so that when we get through all of this, people are not having to deal with investigations and penalties after the fact.
Thank you, Tony. Yeah, I think this last question that just popped up is asking what do I do if I'm a brand new company and I don't have a established history of payroll and I'm trying to hire people in terms of people.
Well, unfortunately, without a basis, there's unlikely a loan amount that will come from PPP and then ultimately forgiven. The EIDL, on the other hand, still may be an opportunity to receive some operating expenses, though you'll be working with the SBA to try and determine, can you estimate what 6 months of operating expense would be once you're up and typically running at your normal operating amount. So I can't say what that would be. We're still waiting to understand better how the traditional EIDL loan will be calculated, but most likely PPP wouldn't help somebody that's in the very early stages of hiring people.
And Tony, I think this next question touches a little bit on some of the issues you raised. What if I have a 1099 employee and I try to get PPP for them, and then they also file for PPP as an independent contractor? Is that going to cause me problems?
You know, I'm not quite as conversant as Tim in the actual rules. It sounds a little bit like double dipping. And if the company is applying for PPP and giving you those funds, it probably is inappropriate for you as a separate 1099 to be seeking funds yourself. That's double dipping. But I think one of the speakers earlier said that one person or a company can apply for PPP for the business side of the house, and then you as the individual can apply for unemployment for your personal expenses, which may be the better way to go about something like this.
And what do I do, Tim, if I have sort of lumpy compensation for employees? I pay them, I don't pay them on a regularly weekly schedule, but I pay them once a quarter or even less frequently. How do I prorate it, or what do I do?
Well, up to you, as long as you make compensation payments within that 8-week period, and that's going to be to determine how much of that the amount that ultimately will be forgiven is based on what you pay them in that 8-week period. So completely up to the business owner.
All right. Well, I think we've kind of run out of time and run a couple of minutes over. I think this was very helpful and educational for all of us. If there are follow-up questions, you can probably contact some of our panelists and ask them after the fact, and we will. I think that we've done a good job addressing. Oh, no, I got one. Nope, it's not a question. So I think we're done for now, and I appreciate everyone joining us today. Thank you.
Thank you very much.
Thank you for including us.
Thank you.
Thank you all.
Will we be getting a copy of this presentation?
I can make it available, and I'll send it through NVTC, and they can make it available for everybody.
Anyone who's interested in a copy of that, feel free to email me, mhardman, MHARDMAN @nvtc.org, and I'll send it out.